persons, and unless you have the knack or the skill to handle the situation when you are faced with such kind of a situation, it's very difficult in courts if your drafting is not right. In fact, in one matter, in a writ appeal matter, we had relied on one document. Unfortunately, the document was in Kannada. So the judge who was hearing the matter did not know Kannada, so we had to furnish a translation. While furnishing a translation, unfortunately, the translator has used a negative word, not. Well, the translation was wrong. So when it was being read to a judge who knew only English, that document had to be read only as not, which is negativing the entire case of the appellant. The judge said, look here, your document says not, but you're arguing as if it is not. It is not. What is that you're arguing? So these kinds of embarrassing situations as lawyers we face every day if we have not been meticulous in drafting our petitions and plaints. Therefore, the importance of the subject, drafting pleadings. Now, drafting is not a separate subject. Pleading and conveyancing are two separate subjects. And drafting is only a prefix. That is, you are drafting pleading, how to draft pleadings and how to draft conveyancing. Now, I told your professor Mahatesh that I'm only speaking on pleadings. That too, a very little introduction to that subject, because even the pleading subject is very vast. And if I want to go to conveyancing, then entire year of your time will be required to say how the drafting conveyancing is important. So let me not touch the subject of conveyancing. Professor, with your permission, I am concentrating only on pleadings. Now let me give you one example of a case. It was a landlord-tenant dispute. The landlord filed a case for eviction of the tenant. The tenant contested the matter. The matter went on for some time. And after full dress trial, that is to say, evidence, cross-examination, arguments, and judgment, the tenant lost the matter. That was filed before a civil judge's court, what was earlier called as a munsif court. Then the tenant appealed to the district judge's court under the Rent Control Act. The district judge also went through the matter and then said there is no merit in the petition filed by the landlord and dismissed it. Then he went to revision into the High Court. In the High Court, every argument was advanced. When they found that they are not going to succeed, they said, all right, give us some time to vacate. The Honorable Court granted 6 months time for vacating. That 6 months period got over. The tenant filed an application for extension of time, saying that he couldn't find an alternative accommodation. Give me some more time. That time was also granted, and that extension was sought another 2 times. Then what happened? They found that now they cannot manage much. So they have exhausted all the remedies. I don't know why they did not go to Supreme Court. The tenant set up his son to file a separate case, saying that it is actually the son who is the tenant of the premises, not the father. The father and the landlord have played fraud on the court. They have colluded with each other and filed an eviction petition. That eviction petition is not binding on me. Therefore, prevent the execution, injunct the execution of that decree for eviction. The other side, and the ex parte injunction order was granted. The tenant was furious. The landlord was furious. He filed an application for vacating the stay. And on coming to know this tactics, the High Court had granted extension of time and all those things. The trial court rejected the application for temporary injunction. Against that, a revision petition was filed before the Honorable High Court. Unfortunately, the case came up before the same judge who had dismissed the matter earlier and had granted extension of time. However, the judge was very magnanimous and he said, all right, you take another 5 months time and vacate. And subject to condition that the suit that you file will be withdrawn. Then that happened. Everybody expected that after 5 months time, they will vacate the premises. But you know what they did? They withdrew the earlier suit that was filed before the Munsif court. The son filed one more suit suppressing the fact that he had lost the case and had got a 5 months time from the High Court. And the trial court, it seems the judge was a new judge. He had newly appointed judge. So he granted an ex parte injunction order again, saying that the tenant's son shall not be vacated from the premises. Again, the respondent came and the respondent appeared and explained all the situations. Then the interim order was vacated. When that interim order was vacated, the son went to the High Court for revision again. It came up before the same judge who granted extension of time on 2 occasions. Then the advocate filed an application saying that since this judge has already heard the matter, he is prejudiced in this case, so he should not hear the matter. Kindly see what kind of tactics are employed. The judge writes in the order that he spent a sleepless night. However, later on, he made up his mind and said, there's nothing in this matter, it should be dismissed. Case was dismissed. It did not stop there. The matter was taken to Supreme Court. And the matter came up before the great V.R. Krishnaiyer and Jaswant Singh bench. And this case is reported in the law reports. And this is a classic case to show what is the need for drafting proper pleadings. You may also note down the citation. 1977, Volume 4, Supreme Court Cases 467. 1977, Volume 4, SCC 467. T. Arvinda Andam versus TV Satyapal. For your benefit, all of you may see paragraph 5 of this judgment, where the judge refers to what George Bernard Shaw remarked on the assassination of father of the nation, Mahatma Gandhi, that it is dangerous to be too good. And then says, I would want to read this. I quote, "We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and unrepentantly resorted to. From the statement of the facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Munsif's Court, Bengaluru, is a flagrant misuse of the mercies of the law in receiving plaints. The learned Munsif must remember that if on a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7, Rule 11, CPC, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting, please see this, and if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the parties searchingly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. The trial courts would insist imperatively on examining the party at the first hearing so that bogus litigation can be shot down at the earliest stage. The penal code is also resourceful enough to meet such men, Chapter 11 of CRPC, and must be triggered against them. In this case, the learned judge to his cost realized what George Bernard Shaw remarked on the assassination of Mahatma Gandhi is dangerous to be too good. So clever drafting, as lawyers, let me tell you honestly, clients will come to us for clever drafting only. In fact, in one matter, a client had approached me and said, "Sir, I don't want you to narrate the facts. I want you to twist the facts and get me an order." But as officers of the court, there's a responsibility on all of us to arrive at the truth. The inquiry, the trial before the court is for inquiring into the truth. So as a practitioner of law, officers of the court, our duty is to draft the plaints as simple as possible and as legally as possible and as truthful as possible. That is the reason why we have been assisting the court. We are officers of the court. We must not identify ourselves with the clients. You may say, "Sir, the client is the one who pays our fees. He takes care of our livelihood. What he cannot do it, we have to do it on his behalf." In fact, there is a criticism against the lawyers that you must have read in Law and the Ethics, that lawyer is a prostitute who sells his knowledge for the purpose of fees he takes. That's too severe a criticism on our profession. Of course, the very same Bar Council ethics requires us that if we are practicing in a particular field of law, we have no right to refuse a client. If a client comes to us, we have no right to refuse, knowing fully well that he has done a mistake or he has committed an illegality. I cannot say I will not appear for him. The only maximum thing that I can do is protect him within the four corners of law. In fact, if you read the book by C.H. Hanumantraya, senior advocate, lawyers vagaire anta avaru ಏನು books ಬರ್ದಿದ್ರು, that he has compiled into a book. Each and every instance where you see he is saving his clients, it's all based on cases, legal acumen, and loopholes in the prosecution. Nowhere sharp practice was practiced. Therefore, don't think that if we don't do truthful practice, we cannot succeed in the profession. In fact, it is the truth that ultimately prevails. And as lawyers, if we say the truth, our respect in the profession, our confidence with the system will be enhanced. Today, we have reached a stage where people are losing confidence in the judiciary because of the delay. Why this delay? A classic example, which Justice Krishna Iyer has quoted in paragraph 5 of this judgment: clever drafting to create an illusion of a cause of action. This is the bane. And as lawyers, we are required to ensure that drafting is not clever for the purpose of defeating the law, but for the purpose of advancing the cause of justice, advancing the rule of law. Your Honor, there's one more aspect which I'll have to highlight in this case, where the judge appreciated the truthfulness and frankness of the advocate who appeared for the son of the tenant. In fact, in paragraph 2, this is what they state: "We desist from taking action against the son or the petitioner because of the sweet reasonableness of counsel Sri Ramashesh." Kindly see, as lawyers, we have actually, our advocate, Mr. Ramashesh, actually helped a person not to get into the other side of law. His sweet reasonableness saved his client from getting adverse orders from the Supreme Court, like imposition of cost or initiation of contempt proceedings and things like that. At the end, they say, "We must appreciate Sri Ramashesh for his young candor and correct advocacy." So this judgment should be a guiding light for all of us while drafting the petitions, while drafting the pleadings. With this subject introduction, I think you will appreciate what is the importance of drafting in law. Now, there are some tips which I want to give you all. Of course, when you come to the profession, you will realize that the kind of drafting that is taught in the law colleges may not be the same that is practiced in the courts of law. But this is the starting point from where you will have to start. See, under the Karnataka Code of Civil Procedure 1908, Order 6, Order 7, and Order 8, the three chapters dealing with the pleadings. Now, when I say a pleading, let me start with a plaint. Now, there are several parts in the plaint. First is the cause title. Cause title is what we can say as the heading of the case, in which court the case is filed, what is the case number, who are the parties. This is the cause title. As I told you in the beginning itself, the description of the parties is very essential. Otherwise, what happens, you know, it will result in delays. If you don't describe the person properly, as I told you, if you change the gender, when the suit summons goes through, takes the suit summons to the place, the person will say, look here, you have addressed it to Rajeshwari. I am not Rajeshwari. I am Rajeshwara. I am not Anjanamma. I am Anjanappa. This is not addressed to me. I will not take it. Therefore, you will have to ensure that the description of the party is correct. The second is the address to which the notice is to be sent. If you don't furnish the address to which the notice is to be sent, then what happens? There will be delays. The summons of the court will not be served. Now you may say there is GPS. So wherever you want to go, if you put that GPS latitude, longitude, you will go to reach the place. But that is not as simple when the suit summons is to be served. Of course, now there are amendments to CPC which says that you can serve it through email, you can serve it through WhatsApp, provided rules are framed by the High Court. But traditionally or conventionally, we'll have to furnish a postal address, because under the General Clauses Act, a notice in writing is deemed to be served by post if it is properly addressed. If it is not properly addressed, then even if the notice comes back unserved, there is no service of notice at all. So you will have to properly furnish the address. Then comes the provision of law under which the suit is to be filed. Generally, we say it is Order 7, Rule 1, CPC, read with Section 26 and 33 of the Code of Civil Procedure. Then we give the address of the advocate who appears for the client. Then we go on to state or narrate the facts. So while narrating the facts, Order 6 says how the pleadings are to be there. Now let me take you to Order 6. I hope all of you are carrying CPC with you. Now Order 6 begins with pleadings. Rule 1. Pleading shall mean plaint or written statement. So in a conventional original suit, there will be a plaint, that is the case made out by the person who approaches the court, and a written statement, that is the defense of the other person against whom the suit is filed. Then the next rule is pleading to state material facts and not evidence. Now, material facts. What are material facts? Material facts are those facts which are necessary for the decision. And to add to this, I must say, it's not only that you must state material facts, but you must also not suppress the material facts. Suppression of material facts is dangerous. In fact, under the Specific Relief Act, there's a particular provision in Section 41 which says that if a person has not come to court with clean hands, then the court can refuse to hear him. So you have to not only state the material facts, but also not suppress the material facts. In the Supreme Court judgment, which I referred to, Arvindanam matter, the fact that a suit was filed earlier, an injunction was taken, time was granted by the High Court, all these facts should be reflected. It should not be suppressed. So if you suppress that, that would be a material suppression of fact. Therefore, material facts to be stated and not suppressing material facts are essential for a decision in the case. Then not evidence. Evidence is proof of how you are going to establish your case. For example, I take the simple example of landlord-tenant relationship. I am the owner of the property. So and so, the defendant is the tenant of the property. I need the property for my use. I issued notice to the tenant to vacate. He has received the notice. He has not delivered back the possession. Therefore, I have filed this case. This would be material facts from the point of view of a suit for eviction by landlord against the tenant. And what are the material facts? What are the documents to be produced? If there is a rental agreement or a rent receipt, these will be material documents. But you don't have to say in your plaint that so and so is a tenant. I approached him on such and such a date in the presence of so and so people and requested him for vacating the premises. He did not vacate. All these are evidences which you will have to bring it in the stage of evidence, not at the stage of pleadings. Then the important mandate under Order 6 Rule 2 is it should contain facts in a concise form. Concise form. See, let me tell you honestly, in courts there is docket explosion. To get your case heard by the court, it takes 5 years, 10 years, 15 years and things like that, because you are in the queue. People who have approached the court before you are to be given justice before the court comes to you. So as lawyers, we have to develop the habit of being precise and concise. The court will not have time to listen to detailed arguments these days, nor the court will have time to go through voluminous documents and lengthy pleadings. Ultimately, the court should be in a position to understand our case very quickly, and that is possible. In fact, I have to quote an example here. Honorable Mr. Justice, the Honorable Supreme Judge of the Honorable Supreme Court, had come to KLE College for judging a moot court competition. At that time, he said, he gave a tip, his lordship gave a tip to the young lawyers. Before you do anything in the matter, first and foremost that a lawyer must understand is to understand the jural relationship. If you understand the jural relationship, then you can draft the pleadings properly, as also conduct the case properly. So what is this jural relationship? When you go to court, your plaintiff and defendant is there. But what is that relationship? In law, is it a relationship of husband and wife? Is it a relationship of landlord-tenant? Is it a relationship of vendor and purchaser? Is it a relationship of employer-employee? Is it a relationship of master-servant? Is it a relationship of father-son? If you can understand this jural relationship properly, then the law can be applied properly. Suppose it's a case of a specific performance suit. If you understand the jural relationship of vendor and purchaser, then under Section 55 of the Transfer of Property Act, you know what are the rights and duties of vendors and purchasers. So to know the jural relationship is important. See, when I give this such examples, it's easy to say the jural relationship is husband and wife, the jural relationship is father and son. But if I give you a case where it involves a complex facts like a tortious action or a breach of contract or a breach of trust. If a case involves such a kind of a situation, how we are going to decide what is the jural relationship? For example, there's a contract between A and B to of master and servant relationship. Then what happens? This servant is weaned away by another person and taken to his company to work. And at that time, he has taken some confidential information which was given to the employee in a what is known as a trustworthy situation. Now here in such a matter, what is the role of a lawyer? He has to first say whether the jural relationship is based on contract, or there is a tortious wrong committed, or there is a breach of trust. So first we have to understand the jural relationship before we proceed to draft the plaint. Then narration of facts, then production of documents is the next issue. Next point, that will be Rule 9 of Order 6, Rule 9. We have the habit these days, because we are practicing on the High Court, in the writ proceedings, of narrating everything in the petition itself, including extracting the statutory provisions, extracting the contents of the documents and all those things. Order 6, Rule 9 says that you don't have to extract the contents of a document, but you have to only say the effect of the document. So that is like, you don't have to say on such and such a date, I issued a notice to the tenant in calling upon him to vacate the suitable property, which is described in the schedule hereunder. No, such details are not required. You can simply say the plaintiff issued notice to the defendant to vacate the premises. The notice is herewith produced and marked as document number so and so. Not necessary to reproduce the contents of the document. Then, one more important aspect as lawyers will have to take care is the limitation period. Within what time the case has to be filed. We have the Limitation Act 1963, which says for each case or each cause of action is a particular period of limitation prescribed. So we have to know whether the suit that we are going to file is within time. Unless we know that suit is filed within time beforehand, if you go and file a case, the other defendant will take a defense that the suit is barred by time, and then even if you have a meritorious case, your suit will be dismissed. In fact, under Section 3 of the Limitation Act, even if the defendant has not taken a defense that the suit is barred by time, the court has a duty to find out whether the suit is within time. So that is most important for a lawyer, to find out whether the suit is within time before drafting the pleadings. Then there's one more aspect of giving necessary particulars. Suppose, see, under the Contract Act, if a fraud is played or an undue influence is exercised or force, coercion is implied, then the contract can be avoided. There's no binding legal relationship. So while giving particulars, we'll have to say in the pleading itself that for what reason we are saying that a coercion was employed or undue influence was employed or fraud has been played. It's not sufficient to say that the contract is not binding on me because fraud has been played or because undue influence was exercised or coercion was employed. We'll have to say what was the nature of fraud. You have to give what is called as details of fraud, details of undue influence, details of coercion. Merely reproducing the word fraud, coercion, and undue influence will not help us. What we'll have to say, for example, undue influence. So and so was my senior. I was working with him as a junior. He called one day and said, you have to agree for this thing. If you don't agree for this thing, I will not ensure that the clients give you fees. So for fear of not getting the fees, I did this. So these kinds of particulars are to be furnished in the pleadings. Then there are condition precedent and denial of a contract, departure, implied contract, relation, all those things. If I go on saying all those things, it will take a lot of time. Of course, your lecturers and professors who deal with CPC and drafting will be of help to you. Then comes the most important aspect of before coming to the important aspect of prayer, I'll come to the aspect of court fee. See, in every courts, there is levy of court fee. I am broaching this subject because you must know as to be lawyers that payment of court fee is also an aspect which you will have to take into consideration, because if your pleadings are not all right, then under the Court Fees and Suits Valuation Act, your client may be burdened with a higher court fee. Let me give you one small example. Suppose you say that plaintiff is the owner of a property. He is enjoying the property under he got the property under a sale deed dated so and so. Defendant is interfering with the possession of the plaintiff with respect to suitable property, and therefore prevent him from interfering with the possession. It will be a clear case of injunctive relief because the plaintiff is in possession of the property. For that, under the Karnataka Court Fees and Suits Valuation Act, only 25 rupees court fee is payable, sufficient. Instead of saying in simple words like this, if you were to say that plaintiff is the owner of the property, but he had gone to America. Well, he came back to India. When he came back to India, he found that the defendant had put up a shed and surrounded the property with a compound wall without authority. He is not the owner of the property. Therefore, prevent him from interfering with my possession and entering the property. Then the loss will mean that you are not in possession. If you are not in possession, then your relief is not injunction, but you will have to ask for possession. And if you ask for possession under the Karnataka Court Fees and Suits Valuation Act, you will have to pay court fee on the market value of the property. That may run into lakhs of rupees, because in Bangalore, you know, today no property is less than a crore of rupees. So for 1 crore of rupees, you will have to pay court fee more than 2 lakhs or 2.5 lakhs. So we'll have to be very careful while we are drafting the petition, because this is also important, because if you look at section 34 of the Specific Relief Act, it says that a declaration in suit is, in a declaration suit, if you don't ask for a further relief, then the declaration will not be granted. Suppose you say you are the owner of the property, declare you are as the owner of the property, and I am in possession, you should not interfere. And the court comes to the conclusion that you are not in possession, then the court will say your effective relief was possession, but you sought only injunction. Therefore, I am not going to grant you the relief. Petition may be dismissed. Therefore, all these aspects will have to keep in mind. 1, provision of law under which you have to file the case. 2, limitation period. 3, effect of a document. 4, amount of court fee that is payable. 5, the jural relationship. And now I come to the end, prayer. What is the prayer to be asked for? Unless you ask for a specific prayer, even if your case is decided in your prayer, in your favor, it's not possible for you to get the realize the relief that is granted. In fact, there's one judgment of the Supreme Court recently in Rahul Shah's matter, where the Supreme Court quoted a judgment of the 19th century of the Privy Council, which said the real difficulty of a litigant in India starts after he gets a decree. That's because to execute a decree, it takes a lot of time. And in that Rahul Shah's matter, which I said, suit was filed in the year 2000. Relief was granted in the year 2006 for possession. The tenant, the owner of the property did not get possession till 2022. It was dragged on and on and on. So therefore, unless a specific prayer is made and granted in execution of the decree, if prayer is not specific and clear, you will face problems in execution of the order. Therefore, seeking the correct prayer is essential. So, as a lawyer, when we draft the pleadings, all these aspects have to be taken into consideration. And coming to the written statement. Now, the standard practice earlier was deny everything, because it is a plaintiff who has to prove everything. So, deny everything. But now, let me bring to your notice the Commercial Courts Act, which has come into force from 2015, where the rules of pleadings are made much stricter. You cannot simply deny a fact. You will have to give your version of the story and say how the plaintiff is not entitled to the relief. It's not simply denying the case. So these are the various developments that are taking place to ensure that the process of law is litigant friendly and not for the purpose of lawyers to make pedantic arguments. So I thought these are the things which I have to share with you. I think I'm almost done with my time, and I think I can take some questions if you have some doubts. Of course, what I have said to you may not be new, and it may not fetch you marks in your examination. But ultimately, what theoretical knowledge you have, you should use it or apply it in the profession. Only then you'll be able to get relief to your client. I conclude by saying that one anecdote, a senior lawyer was arguing the matter before a high court judge, and the judge asked the senior lawyer, do you think you can get relief to your party with these kinds of arguments? The advocate replied, very, very in a witful way. It's in Telugu. I'll first say it in Telugu and then translate it for you people, if people do not understand Telugu. My lords, ma kastumu, mi istumu, val adrustumu. That means it's my effort to convince my lords, and it is the will and wish of my lords to get convinced. And ultimately, what decision my lords gives would be the fate or the fortune of my client. So ultimately, the justice is different. But as lawyers, we'll have to render our obligation to the client and see that best possible pleadings are drafted so that the client gets the relief. Thank you very much for giving me an opportunity. I thank Principal Professor Mallikarjunayya, having felt that I would be a person to speak to you people, and Professor Madivalar, having taken the pains of organizing this talk, which gives me some opportunity to interact with the new brains and fresh minds. Thank you very much.
Thank you so much, sir. Our students are getting these benefits. Now I will ask students if they would have any questions. So, okay, fine. If you are having any questions, you can post in chat box also. Prasad sir, is there any questions are there?
Sir, one girl from BA, I think Aditya Chaurasia, she has raised her hand. Sir. She can ask it through this thing itself. You can speak and ask orally.
Okay, fine, sir. Yes, you will be allowed now. Before that, any questions are there in chat box, please? Okay. Okay, sir. Fine. One thing, just I am asking one question. With respect to the IAS, sir, when can we file the IAS? With respect to that, also you can enlighten
Sure,
uh,
sure,
with
sure.
respect to the IAS, sir.
In fact, the Supreme Court has said in Advocate General Bihar's case that filing successive applications is a case of daring raid on the court and amounts to contempt. In fact, there are cases where more than the case, applications will be 30 numbers, in 80 numbers, 100 numbers. So these are all the ploys and tricks of the trade which advocates employ to drag on the matter. Applications are filed for furthering the cause in the case. For example, applications are filed for, suppose one of the parties dies in the case and the cause of action survives. An application is filed to bring his legal representatives on record. And for example, applications are filed for the purpose of seeking a temporary relief till the main relief is granted. Applications are filed for appointing a receiver of the property which is in the danger of being wasted. Applications are filed for appointment of a commissioner to do local inspection to see what's the nature of the property, whether the property is in the manner what the defendant contents or plaintiff contents, or to decide the boundary dispute and things like that. Applications are filed mostly by lawyers for amendment. This aspect I left out. Order 6 Rule 17. Applications are filed for correcting the errors made in the pleadings. So this is one classic case where time is dragged on by keep on changing your stand.
Aditya, you can ask the question. Unmute yourself. You can directly ask the question to sir.
Good morning, sir. I'm
Good morning.
Aditya. My question is, you said that in the pleadings, you do not need to mention everything in detail, correct? So it's just a clarification that for suppose if I am saying in my pleading of divorce petition, that the particular like for suppose the judicial separation decree was passed and now that I'm filing for the divorce, so do I need to make a mention that judicial separation was filed on so and so date and on so and so decree?
You'll have to refer to but you have to give the particulars of the document. That is when
yes,
the judicial,
so that's what I was asking. You
yes,
said the detailed description, so sir, writing the date and everything includes na. If I just mention that judicial decree of the number of the petition, that OS number so and so is attached to this
yes,
particular petition
yes,
named as annexure 1, will this
what
suffice or do I need to
by
give?
a judgment and decree dated so and so, passed in MC number so and so, the honorable court has granted judicial separation. A copy of the said decree is produced herewith.
Okay,
That
so
should be
I
sufficient.
don't need to like make a brief mention of the facts also, no? I don't
Not
need
necessary,
to write.
not necessary.
Not necessary, no? Okay,
Not
sir. Thank you.
In fact, under the CPC, there's a separate appendix on pleadings, appendix A on pleadings. All our pleadings have to more or less be on these lines. Appendix A governs the forms of pleadings for written statement and plaint. Appendix A to CPC. In fact, I remember one judgment of Supreme Court where they said that a suit for specific performance was not according to form number 47 of CPC and therefore rejected the plaint.
Any other questions here? Sir, one question is here. Prasad sir, please read.
Sir.
Sir.
Is it mandatory to mention the synopsis in RFA? That's the question,
Yes,
right?
sir. Yes, sir.
Yes,
RFA,
yes.
is it mandatory?
See, under the Karnataka High Court rules, it has been amended to furnish synopsis in all the petitions now, including RFA also. All petitions is required. Okay. In fact, even the synopsis run into number of pages.
Sir. The students can directly ask the questions to sir.
See, when I was in the college first year LLB, we had an English professor. So there was a test. I answered the test and I underlined some portions in my answer. I got a good marks in the examination, but there was a comment at the end. The professor said, impress by your style, not by underlining. So ultimately, what we have to say, our words must speak.
Sir, in
Sir.
appeals particularly,
Ah.
What is that we have to be very conscious of? What is that point? Is there any like important element which we should always remember?
Sir, ultimately, sir, you have to raise a ground of challenge to the appeal.
Yes.
For example, if I give you a case of temporary injunction is granted by the Honorable Court and you file an appeal before the appellate court. Okay. See, the normal ground that you can say is the Honorable Trial Court failed to appreciate that the defendant had not established, the plaintiff had not established prima facie case, balance of convenience, and irreparable loss and injury. Therefore, the trial court exceeded in the jurisdiction of exercising its powers under Order 39, Rule 1 and 2 CPC. This much ground is sufficient. Honestly speaking, this much ground is sufficient. When you go to the court and argue, there you read out the judgment and say, look here, look at the facts of the case. These are the documents produced. There is no prima facie case. You don't have to narrate in detail what is the how prima facie case is not made out. That would be a case of written argument. Yes. If you go on narrating each and everything, it would be a case of written argument, not a memorandum of appeal. But increasingly, because of our flair for the subject and our flair for the flair to show that we know things, we go on drafting lengthy appeal memorandums also. There, we have to make a distinction between a written argument and a memorandum of appeal.
Thank you, sir. Thank you very much.
So, sir,
any other questions? Kindly ask. Sir, it's a very good opportunity. Okay, practical knowledge is different, theoretical knowledge is different. Okay, so please ask the practical aspects.
One more aspect that is noted in the Karnataka High Court writ proceedings rules is that you will have to state the facts in a chronological order. We don't have to jumble up facts. If you are narrating facts, the facts have to be narrated in a chronological order. That is, first things must come first.
Correct.
Subsequent things will come later. Then, see, even when we are preparing for the case, if you know the sequence of events, 50% of the job is done. You'll know whether your client is going to get an order or is not going to get an order, because you yourself can make out by knowing the chronology of events. Who is the first person who has committed the mistake? So better to understand the facts in a chronological order. That is also most important skill to be developed while narrating the pleadings. And sentences should be very simple. Should not have a compound or a complex sentence. Short sentences. You take any book, any novel which have caught the attention of the people, where there are only small sentences employed. Don't have a lengthy sentence. You don't have a lengthy pleading and don't have a lengthy sentence. Don't have a lengthy paragraph. Make short paragraphs, short sentences, and short pleadings, so that judge understands your case properly. So keep it simple. That's the best tip that can be given. Keep it simple. Otherwise, there's a grapevine in our legal circles, and you must also have heard by this time. You first convince the judge. If you can't convince the judge, then confuse the judge. Those kinds of things will not help in the long run. We'll always have to convince the judge.
I think. So, Prasad sir, any questions are in chat box? No questions, sir?
No, sir. I am not finding any questions.
Yes,
Sir, I would request all your students to read that 1977 judgment of Justice Krishna here.
Okay, sir.
That is very important because
Okay.
it gives us how our system is being taken for a right. Even after the
So I will-
judgment, things have not changed. Things remain the same. There is allegation of misleading the court, suppression of material facts and things like that.
Okay, sir. I will arrange it, sir. I will print out and I will distribute to the
Please,
students.
please.
Prasad sir, shall we go for conclusion session?
Yes, sir. Yes, sir.
Sir, our principal sir not able to enter the room because of he is having some work.
No problem, no problem.
Okay, sir. Prasad sir, go for concluding session.
Yes, sir. Yes, sir. So, good morning, one and all. I deem it a privilege to render a vote of thanks in this workshop organized by KLE Society's Law College, Bengaluru. First and foremost, I thank today's guest advocate, Shri Rajeshwara PN Sir, Bengaluru, who happily obliged our request to enlighten us about drafting of pleadings. And we look forward to have many more such sessions in the coming days. I owe special gratitude to our respected principal, sir, Dr. J. Mallikarjunaya, and IQAC coordinator, Dr. Manoj Kumar V. Raymond, sir, for their kind cooperation and encouragement, which made this event possible. I also thank Dr. Mahantesh B. Madiwalar, sir, for organizing this event, and Shri Tanmay J. Patil, sir, Assistant Professor, for his technical support, and Ms. Ashmita, Assistant Professor, for introducing and welcoming the guests and the participants. Last but not the least, I must thank all our students and also the other faculty members who have attended this event. Thank you all. Once again, have a nice day.
Thank you, Prasad ji.
Thank you so much, sir.
Thank you, sir.
Thanks for your kind cooperation and also thanks to all your colleagues, sir.
Thank you, thank you, thank you.
Thanks to the other students as well as faculty members, those who have